To gain an understanding of law, one must first recognize the different realms of that law they can exist in. When we communicate with others, it is either through God-given beliefs, contracts, or property concerns. And so follows the rules of law. Genesis 1:26-28, King James Version. And God said, "Let us make man in our image, after our likeness, and let them have dominion over the fish of the sea," maritime law, and over the fowl of the air, ecclesiastical law, and over the cattle, and over all the earth, and over every creeping thing that creepeth upon the earth, common law. What is law? Law, a body of rules of conduct of binding legal force and effect, prescribed, recognized, and enforced by controlling authority. In U.S. law, the word law refers to any rule that, if broken, subjects a party to criminal punishment or civil liability. Laws in the United States are made by federal, state, and local legislatures, judges, the president, state governors, and administrative agencies. Law in the United States is a mosaic of statutes, treaties, case law, administrative agency regulations, executive orders, and local laws. U.S. law can be bewildering because the laws of the various jurisdictions, federal, state, and local, are sometimes in conflict. Moreover, U.S. law is not static. New laws are regularly introduced, old laws are repealed, and existing laws are modified. So the precise definition of a particular law may be different in the future from what it is today. The U.S. Constitution. The highest law in the United States is the U.S. Constitution. No state or federal law may contradict any provision in the Constitution. In a sense, the federal Constitution is a collection of inviolable statutes. It can be altered only by amendment. Amendments pass after they are approved by 2/3 of both houses of Congress, or after petition by 2/3 of the state legislatures. Amendments are then ratified by 3/4 of the state legislatures or by conventions in 3/4 of the states. Upon ratification, the amendment becomes part of the Constitution.
The Declaration of Independence is a document that was adopted by the Continental Congress on July 4, 1776, and signed on August 2, 1776. It was a formal statement announcing the separation of the 13 American colonies from British rule and establishing the United States as a sovereign nation. The document was written primarily by Thomas Jefferson, with input from a committee that included John Adams, Benjamin Franklin, Roger Sherman, and Robert Livingston. The Declaration of Independence is divided into three main parts. 1. Introduction *. This section explains the purpose of the document and asserts the self-evident truths that all men are created equal and are endowed by their Creator with certain unalienable rights, including life, liberty, and the pursuit of happiness. 2. Indictment *. This section lists the grievances against King George III, detailing the ways in which he had violated the rights of the colonists and abused his power. 3. Conclusion *. This section declares the colonies to be free and independent states, absolved from all allegiance to the British Crown, and establishes their power to levy war, conclude peace, contract alliances, establish commerce, and perform all other acts and things that independent states may of right do. The Declaration of Independence was a significant event in American history, as it marked the beginning of the United States as a nation and set the stage for the country's development as a democratic republic. It is celebrated annually on July 4, which is commonly referred to as Independence Day.
Importance of the Ecclesiastical Law. If you think ecclesiastical law is not valid in real law practice today, you are not paying attention to the signs. Things like oaths under God, swearing on the Bible, testifying or giving a testimony in court, The only thing they don't tell you or show you is how deep the impact of the Bible and its use as ecclesiastical law really is. Year of the Bible. Public Law 97-280, 97th Congress, October 4th, 1982. Legalese. One of the most important aspects of law is how to speak the language of law. For the purpose of this and for the purpose of dealing with anything when it comes to this government, you have to understand that the words you use mean things, and that specific words mean specific things. Law is for land, and code is for artificial persons. Legalese refers to the formal, technical, and often difficult to understand language used in legal documents, such as contracts, deeds, and court opinions. It is characterized by complex sentence structures, archaic words, and specific legal jargon. The purpose of legalese is to provide The United States Corporate Constitution refers to the various laws, regulations, and court decisions that govern the rights and responsibilities of corporations in the United States. This includes the rights of corporations to exist as legal entities, to enter into contracts, to own property, and to be protected by the law. All the 13th Amendment did, if anything, is make slavery legal and still did absolutely nothing for the status of the newly freed slaves of non European descent. Nothing about it brought the Black people in to be included in the Constitution, as it would appear. Thus, the creation. Please note that this presentation is strictly for educational purposes. We encourage you to conduct your own research to verify the information provided here and apply it appropriately to your unique circumstances. It is important to recognize that each person is responsible for their own use of